Good afternoon. My name is Preet Bharara, and I'm the United States Attorney for the Southern District of New York. For some time now, we have been investigating potential corruption and fraud at Valeant, the large pharmaceutical company. Our investigation into the different ways Valeant shareholders and the marketplace may have been harmed continues. But for today, we allege fraud that we unearthed involving Valeant and a company named Philidor, a specialty mail-order pharmacy with close ties to Valeant. Specifically today, we have arrested and charged two men, Gary Tanner, a former senior executive at Valeant, and Andrew Davenport, the founder and CEO of Philidor. We allege that these two men participated in a fraudulent scheme to illegally use Philidor as essentially a vehicle for personal profit and self-dealing. As alleged, these two men purported to be arm's-length business counterparts, Tanner with Valeant and Davenport with Philidor. But they were, in fact, we allege, partners in crime. The crime allegedly boils down to this. Tanner was a senior executive at Valeant. As such, he owed all of his duties to Valeant and its shareholders. In violation of those duties, however, Tanner secretly agreed with Davenport to puff up Philidor's business. Why? So that eventually, Valeant would pay $100 million for the right to buy Philidor. Tanner, we allege, did not do this out of loyalty to Valeant. He did it because he was expecting to get a secret $10 million kickback. And as the complaint alleges, he concealed this criminal self-dealing. He repeatedly lied, claiming he had no personal financial interest in Philidor, when he, in fact, had a huge interest. Before I go into detail about the charges, let me thank some folks, many of whom are standing with me up here today. Cases like this, as you might imagine, involving corporate deception and secret kickbacks are not easy to make. They take time. They require persistence, tenacity, and hard work, and that's what we had here. I am joined today by our partners in this and so many other important cases, the FBI, led by William Sweeney, the Assistant Director in charge of the New York Field Office. I want to thank Bill and his team, specifically FBI Special Agents Ryan Riddell, Michael Priest, Wayne Boddy, and Tom McDonald for their incredibly hard work on a complicated case. I also want to thank the career prosecutors from my own office. They are Howard Master, Ian McGinley, Robert Allen, and Richard Cooper. The AUSA is handling the prosecution. And supervisors from our Securities and Commodities Unit, Tim Kasoulis, and in our Complex Fraud and Cybercrime Unit, Paul Krieger and Edward Kim. So let me just spend a couple of minutes describing the alleged criminal scheme in a little bit more detail. So in January 2013, Tanner worked with Davenport to help set up Philidor, a specialty pharmacy whose principal business was to sell drugs manufactured by Valeant. As I mentioned, Tanner worked with Davenport to build up Philidor, but sometimes at the expense of Valeant. For example, although Tanner was directed to diversify Valeant's relationships with multiple specialty pharmacies, he instead pushed hundreds of millions of dollars of Valeant business exclusively to Philidor. And as we intend to prove, he did it for the eventual $10 million kickback. Here's how the kickback worked. In 2014, just a year after Philidor was created, Tanner pushed for and succeeded in getting Valeant to agree to an option to buy Philidor for $100 million and other payments. Under the contract, as Philidor's principal shareholder, Davenport was to receive $40 million. But what was hidden was that Tanner would get $10 million of Davenport's share kicked back to him. They had, in effect, illegally converted Valeant shareholders' money into their own personal nest eggs. The complaint also alleges evidence in support of the defendant's deceit, concealment, and criminal intent. Just a few examples. One, Tanner repeatedly refused to disclose his huge financial interest in Philidor even after his supervisors at Valeant became concerned and confronted him with it. As another example, in discussing their scheme, Tanner and Davenport took care not to use Tanner's official Valeant email account, instead creating a Philidor account for Tanner under a fake name, Brian Wilson. They also secretly prepared for the flow of kickback payments. How did they do that? Tanner and Davenport created shell companies in Delaware to transfer their money, including the kickbacks to Tanner. And on the day the option agreement was signed, Davenport set up a bank account for an aptly named shell company called Endgame LLC. As further described in the complaint, both Davenport and Tanner were quick to spend the money on themselves. Just days after the first alleged kickback payments came into a shell company, Tanner wired $6.5 million to pay for personal expenses and investments, credit card and restaurant bills, and put $2 million into his retirement account. Davenport also allegedly used the payout to buy $20 million in securities at his brokerage account, purchase another home, and install a $50,000 custom wine cellar. This diagram shows the flow of the money that's described in the complaint. As I said, Gary Tanner, essentially a Valiant executive, on behalf of Valiant, pushes Davenport's interest at Valiant. The $100 million comes in. The $40 million payment goes to Davenport as the CEO of Philidor. The $10 million kickback to the shell companies back to Gary Tanner. You might read this in the complaint when you have a chance to take a look at it. In one of the secret email exchanges described in the complaint, Tanner and Davenport joked about, quote, riding into the sunset together like Butch and Sundance. In their own words, to ride into the sunset, they just needed to, quote, unquote, keep playing the game. As of today, that game is up. They will not be riding out into the sunset to live in luxury off the spoils of their fraudulent scheme. Rather, Tanner and Davenport will now face federal wire fraud and money laundering charges. Now I'd like to bring to the podium Bill Sweeney.
Good afternoon, thank you. I'm joined to my left by Mike McGarity, who is our newly arrived Special Agent in Charge for our criminal division here in New York. And then to his left is Assistant Special Agent in Charge, John Cassell. Shareholders should be able to put their faith in those responsible for making decisions on behalf of their investments. They should be able to rely on them for placing the shareholders' best interest above their own. But as evidenced by today's charges, shareholders' right to honest services is sometimes exploited by those who engage in kickback schemes that pose significant risks to the investors. As alleged, Gary Tanner used his position at Valiant to support a relationship with Philidor, the specialty mail order pharmacy that worked closely with Valiant. Tanner stood to benefit personally. Andrew Davenport, the CEO of Philidor, provided kickbacks to Tanner for his assistance in advancing his and his company's interests in a variety of ways. At the same time he should have been representing Valiant, Tanner was communicating with Davenport in furtherance of their mutually beneficial goals. In the end, Tanner received approximately $10 million in concealed kickbacks from Davenport out of Valiant's eventual payment of $40 million to acquire Philidor. Davenport received over $40 million from Valiant into bank accounts he controlled. Throughout all the business dealings and negotiations, Tanner never disclosed to Valiant his relationship to Davenport. He ignored Valiant's official code of conduct, of which he was fully aware, and he denied holding any financial stake in Philidor. Thanks always to our partners at the U.S. Attorney's Office, to Preet and your team, Tim Kasoulis, who's the Chief of the Securities and Commodities Fraud Unit, Paul Krieger and Ed Kim, Chiefs of the Complex Frauds and Cybercrime Unit, and AUSA's Robert Allen, Richard Cooper, Ian McGinley, and Howard Master. I also want to thank the members of our investigative team, 3 of whom are still out on the street working, 1 of whom is hiding in the back, to Special Agents Ryan Riddell, Mike Priest, and Supervisory Special Agent Mario Pizzana, who are still out, and Tom McDonald, who is hiding in the back but won't take your questions. Thanks for all the work on this important investigation.
Thanks, Bill. Happy to take your questions. Yeah. Yeah, I'm not going to comment on what particular things are still under investigation. I thought I've made more clear here than even I usually do that the investigation is ongoing. We're still continuing to look at a lot of different things in connection with Valiant and the relationship with Philidor, but I'm not prepared to talk about that today. Yeah. My answer to that is similar to my answer to the other question. There are various aspects of conduct and activity and relationships and how things were accounted for that went on at these companies that I don't want to get into until we're ready to. I'll say for the third time, the investigation continues. Sometimes that means there are further charges. Sometimes that means, that we'll take a look and continue to investigate. And there won't be. If we had the ability to make other charges, to file other charges today, we would have done it. And so the fact that we haven't means that we're still looking and investigating, like I mentioned. Yeah. I have said, and I'll say again, I love my job. I enjoy doing my job. I think we're still doing great work here in the office. I serve at the pleasure of the president, like every U.S. attorney does. And if and when a president decides to replace me, I'll ride off into the sunset.
A question about model immunity before today.
Yep.
In your release, on the indictment, you mentioned in the journal of Anwar al-Awlaki and Osama bin Laden, but you failed to mention that he also wrote the name of a prominent ISIS leader. I'm wondering if there was a reason for that omission from the release and whether or not you believe that his alleged terror attacks were ISIS-inspired.
Yeah, I don't think you should assume anything with respect to what we put in a complaint or not put in a complaint. We don't put everything that we know about any defendant, whether it's in this alleged Hannah Davenport kickback scheme or in the Rahami case or any other case. So I wouldn't read anything into anything. Are there any more? I'm not going to comment on something that's not related to this, and the complaint speaks for itself. Thanks, everybody.